Good afternoon, everyone. Thanks for sticking with us. My name's James Bray. I'm a member of the Recent Call Committee of the CLA, and I'm going to be up here this afternoon giving an assist to Marco and speaking a bit about jury addresses. The sort of presentation we've got for you involves talking a bit about the do's and don'ts, and hopefully we'll have a few minutes for questions at the end. And I'll take a moment to introduce Marco to get started. Marco Sciarra is a criminal defense lawyer practicing in the Greater Toronto area. Marco represents clients accused of all criminal code offenses and has a particular interest in serious violent offenses and a particular expertise in conducting jury trials. Marco has a long-standing commitment to continuing legal education. He's written numerous articles for various legal publications, and he's the host of the Law Garage, which I suspect many people are familiar with. It's a podcast which features informative and entertaining interviews with criminal law practitioners. Most recently, Marco conducted a 4-part series directed at recent calls, and it was titled How to Prepare for Your First Jury Trial. And our presentation this afternoon is to address a part of that series, which Marco didn't have time to cover, which is the closing address to the jury. So Marco, please.
Thanks, James. Thanks, everybody, for having me here. As James just said, what happened is I didn't have enough time to really get into the closing address. And since that series was conducted in March, many of the recent calls that were present for it have reached out to me and asked me various questions about the jury address and closing addresses and so on. So I figured when James and I were collaborating on this presentation, we thought it would be good to focus in a little more in depth on a jury address situation so we can get through the do's and don'ts. And the way we've structured this presentation is that James, as a representative of the recent call, came up with various questions, and through those questions, we have developed this presentation. We broke down the presentation into 3 parts. The first part is the goal of the jury address. The second part will be discussing avoiding possible consequences of a bad jury address. And then part 3 is going to be the most in-depth part, which is the crafting of a jury address, so that we can get into various things, tips and so on. I want to say at the outset that nothing that I am going to be explaining to you is my own work. I basically disclaim any originality. I copied from the people that I learned from, various other lawyers who've given presentation like this in my career, as well as just watching other lawyers. I was able to develop some skills and techniques that I think would be helpful to you guys. So if you've heard some of this from other people, it's because I just pretty much copied it from them.
Okay, Marco, first of all, how much experience should a junior lawyer have before taking on a jury address?
Well, you've all probably conducted some trials in your career. So a jury address is a little bit different because when you're focusing on a jury address, you're focusing on the facts and you're talking to people who are not judges, and the legal aspect of it is not something that the jury, there's ways to deal with it, and we'll get into that. But I think your experience has to be that, it's not going to be your first ever trial. If you've seen some other lawyers conduct jury addresses, you can look at the way they've approached the jury address, where they stand and so on, and just get advice from people and ask people questions on how to approach that. That's what I would recommend, is the type of experience that you need before getting into that aspect of the trial. I think what we need to start with is understanding the goal of the jury address. And it's very simple. It's the role of the defense lawyer to sum up all the pieces of the evidence that you say are relevant in painting a picture for the jury as to why your client should be acquitted. So throughout the course of the trial, the jury's just sitting there, and the Crown, we know what they're doing. They're trying to tell a story. The defense tells their story by asking the questions. The jury's always wondering, why is the defense asking this specific question? Why is the defense leading this piece of evidence? Every piece of evidence that you lead in a jury trial should be something that you might want to comment on in front of the jury. So your role at the end is to take all those pieces of evidence that you have compiled through your examination of the witnesses, through your own evidence that you've called, and use that to sculpt your story and the story that you want to present to the jury. So when you're going to the jury, you want to say to the jury, this is the parts of the evidence that you should focus on. You should focus on the things that I've led. These are the things that I thought were important. And the reason why they are important is because they point to the acquittal of my client. And so it's your job in the jury address to show the jury basically why you have led the evidence that you've led and why it points to the acquittal of your client. So that's always what's in mind. That's what you should keep in mind when you start the jury address.
And how do you adjust your approach when there are particularly vulnerable or sympathetic witnesses?
That's a good question. You have to, in front of a jury, it's different from a judge alone trial where judges are able to separate themselves. You have to craft your examination of witnesses in different ways when you're, depending on the piece of evidence that you need. So you don't necessarily need to do a big, long cross-examination of every witness. If there are 3 pieces of evidence that you need from a witness, you focus those 3 pieces of evidence. If it's a witness who's not necessarily antagonistic, it's just going to give you that evidence that you need, you tease out that evidence. If it's a vulnerable witness or if it's a witness that is somebody who is not going to be antagonistic to you, just get the piece of evidence that you need and sit down. The reason why that's important is because it shines a little spotlight on the piece of evidence that you are interested in. And then once you shine that spotlight and you recall it for the jury at the end of your trial, the jury will remember, when Ms. Smith testified, I only asked her 3 questions, and these were the 3 answers. And the reason why I asked those questions are A, B, and C. Not every witness requires a rigorous cross-examination. And police officers are a perfect example. Some police officers have very helpful information that you want to extract from them. So you just be nice to them, get the information that you need. It's straight out of their notes, get them to sit down. And then they're not thinking that, oh, this lawyer hates all cops. They just want to get the evidence that they need from certain witnesses. And then you spotlight that later.
Okay, how do you approach race, indigeneity, or gender if those are relevant factors in the case that you're working on?
I mean, it depends on the case. If this is going to be a relevant factor, if race, indigeneity, or gender are really relevant factors in your defense, if the accused testifies about their particular status of a particular community and how that changed his impression or in some way affected his decision-making in the crime that he's committed, if it's a self-defense case, for instance, or something to that effect, you want to lead the evidence that you need from that witness enough that you can comment on it to the jury. So you can say, look, my client comes from this community. So he made, and he testified and he made these decisions based on his upbringing and his knowledge at the time, because his personal circumstances are relevant to, for instance, issues of intent or how he might have perceived a particular situation. So when it's important, you want to flesh it out mostly through your own evidence, I think is the best way to do it. And to a certain extent where you have to tease out the evidence from the Crown's case, you have to start leading that. The concern is if you go too far on the Crown side of things, you start questioning the investigation or suggesting that, for instance, the police were racist in particular circumstances, that could open up a can of worms where the Crown may be entitled to call evidence to respond to that. So sometimes it's just easier to lead it from your client. And if the Crown says, well, we want to call a police officer to testify that he shouldn't have felt or shouldn't have perceived the world that way, that would be their decision. But it'd be very hard, I think, to get that evidence in if a person who's from a particular group feels a particular way as a result of their status in that group. So you can kind of lead it as part of your case. I think that's the best way to deal with that type of evidence. Okay. This is all going towards what we can say about it at the end to the jury.
Can you speak to the consequences of a misstep in a closing address?
Yeah, I can speak to that because obviously it's happened to me. I've done a number of jury trials and I've had there's 2 major things that can happen if you cross a line in a jury address. The first thing is you get a corrective instruction, and the second thing is you can get a mistrial. Now, a mistrial is obviously, we know, is a remedy of last resort, and the Crowns are very loath to ask for a mistrial. You really, really have to cross a line in order to get a mistrial. And the reason why the Crowns don't want to ask for a mistrial is because they've put in all these resources into the trial, and they will often ask for a corrective instruction before they ask for a mistrial. If you've done something in your jury address that warrants a mistrial, it's going to be extreme, and it's going to be a mistrial because that's the only remedy. The corrective instructions are not something you want because there's two types. There's a soft corrective instruction and there's a hard correction instruction. I mean, that's not legal. I'm just characterizing it. The soft corrective instruction could be something as minor as, the defense counsel said the witness testified A, B, and C, but really the witness said something different. So, you get a soft correction and that's something you said wasn't accurate. A hard correction is something where the judge will tell the jury to disregard something that the defense counsel has said. Both those types of responses by the judge are not good. You don't want that because obviously your whole thing in front of a jury is to gain credibility throughout the course of the trial. And the last thing you want is the jury to be told that something you did was wrong and that your credibility gets called into question in front of the jury, especially when you're asking them to acquit your client. So you want to avoid any type of corrective instruction from the judge. And specifically, the Crown will object if you've crossed the line, and if you're going to have to be in a position to defend your address and to ensure that no correction is warranted.
Could we have the next slide, please? Okay, so those are the consequences of a misstep in a closing address. Can you speak a bit about avoiding those consequences?
Yeah, this is part of the don'ts aspect of the jury address. So we put them in point form here, and I'll elaborate on some of them. Don't misstate the evidence. In today's day and age, it's very easy to not misstate the evidence because you can order DRDs of the proceedings. They're very cost efficient. If there's a particular witness who's important, you might want to order and use the words exactly as the witness has said, quote them directly, because misstating the evidence, it looks really bad. And if you get that correction, it looks like you're trying to mislead the jury, and the Crown can comment on those types of mistakes in their closing address if they're going after you. So you don't want to misstate the evidence. That's the first thing I recommend. Do what you can to get a copy of the evidence and be as precise as possible with the evidence. And that leads to the second don't, which is don't use imprecise language. And what I mean by that is, it's a good as an example would be, when you're making a submission to the jury, you might say, Mr. X said that my client was innocent. But you might want to say, Mr. X said in cross-examination that my client was innocent. By adding that aspect to it, that precision to it in cross-examination, it makes it so much less likely that you're going to attract a complaint from the Crown attorney, because the Crown might say, well, in examination in chief, he said your client was guilty, and in cross-examination, he said he was innocent. So by using that precision in the language and using exactly how it was said and when it was said, it helps avoid any of those consequences. Because you'll notice, and I know many of you are going to start doing a lot of jury trials the way the state of the law is, you'll notice that the more you make a progression in your defense of your client, especially a client who might, from the perspective of legal professionals, be guilty, and I mean judges and crowns and so on, the more you advance your defense and you're getting better at it, the more they're watching you in the sense of saying, are you going to cross a line? Is there something that we can correct? Is there something that we can fix? So you want to avoid that. You want to be precise in your language. And those little things like that, this is what the witness said in examination in chief. And then this is what the witness said in cross-examination is a good example of precision in language that I would recommend that you use. The second thing is the third thing is don't generalize. Generalizations, for instance, not all police officers are bad. You might have caught the police officer in your case in a lie or a misstep, and in your cross-examination, focus your evidence on this officer or the police who investigated this case. Don't focus on all police. You say all Toronto police would do something like this. When you say when you make generalizations like that, you attract judicial scrutiny and correction, because you're going outside the scope of the evidence, and it's really important to be precise with the evidence. And so focus it on the case here. It leaves the impression that police generally are bad. You don't have to say it. You know, if you've been able to attack the credibility successfully of 3 out of the 5 police officers in the investigation, you don't have to say that all police are bad. It leaves the impression with the jury that all police are bad because 3 of 5 are bad. Or likewise, if you only were able to do it towards one of them, you might take the reverse approach and say, not all police are bad, but Officer Jones really was, you know, not on his game that day and took liberties that he shouldn't have taken. And that shows that you're being reasonable to the jury. You're not, I hate the world, I hate all police. You're saying, we're gonna give him the benefit of the doubt, but on this day, he wasn't good. So don't use generalizations in the affirmative, and make sure that you focus on the evidence in the case. And that's the same, the next thing is don't speculate on things that are not in evidence. And an example that I have for that, we know that we conduct a lot of evidentiary hearings before the trial. Certain evidence gets in, certain evidence gets out. So we have more knowledge than the jury will have. There's a reason why we have that knowledge, is because we have done the trial and evidence has been left or held back from the jury. So the jury's not going to know everything. And if there's something that they don't know that has colored some of the evidence, you cannot at any point in time take the opportunity to speculate on that piece of evidence. You can't leave the jury to speculate. You can't say, well, I wonder why they did do this. You can't leave that to the jury because you know things. And the Crown Attorney might say to the judge in the absence of the jury, you know, defense counsel was aware that the police actually did these things and that evidence was excluded, and yet they left the impression with the jury, or the misimpression with the jury, that the police never did that. And it asked the jury to speculate as to why that might happen. So you can't do that. If you do things like that, it calls into question your ethics, because just because evidence is not admissible in a trial, if you know that it exists and you're pretending like it doesn't, calling for speculation or speculating yourself, that causes a problem and it calls into question your veracity as counsel. Don't state personal opinions. Your personal opinion of the guilt or innocence of an accused, or the credibility of a witness, your personal opinion, I think he's lying, is not relevant. The jury can't consider that. And the easiest way to understand why is because it would be unfair in our society if you are a recent call and you're doing a trial against, you know, a Crown Attorney who's been a Crown Attorney for 30 years, and the Crown Attorney says, well, I think they're guilty and I've been doing this for 30 years. Well, how would you feel as a recent call? You can't challenge that. You can't say, well, I've been only a recent call for 5 years and I can say, so the opinion of the counsel is not relevant because it's unfair. Well, it's not relevant and it's unfair. So don't state personal opinion. But obviously, when you're advocating for your client, you're advocating from a perspective that your opinion as an advocate is coming out. You're saying to the jury, when Mr. X testified in this fashion, I'm going to ask you to disbelieve him. I'm going to ask you, the jury, to find that he's not telling the truth. That obviously leaves the impression that you didn't believe him. That's why you're doing that. You're advocating for that. But your personal opinion saying, I didn't believe him, you have to leave that out. And the last thing is, don't comment inappropriately about witnesses. You know, you can't say, can you believe how that witness was dressed? You can't say, can you know, anything negative about a witness. Or don't comment inappropriately about opposing counsel or any other counsel in the room. Now, you know, I'm not gonna lie, I have, you know, sometimes left an impression that the way Crowns might have conducted their case or presented their case was done in a way that should leave the jury with an eyebrow raised. But I don't make negative comments to them about them as people or as crowns. But for instance, something I said in a case recently was, I said, this was a master class in presenting a prosecution. I said, the Crown put their frail complainant up first and supported their evidence by calling a series of professional witnesses, police officers and experts, so that by the time we got to this stage in the case where you have to make a decision, you might have forgotten how weak the complainant's evidence was. This is prosecution 101, ladies and gentlemen. You know, I've said things like that. Now, that's something that you can comment on in the sense of why is the Crown calling this case or how they called their case, but it's not like, I've had complaints about it, but not really, because it's almost complimentary to the Crown, so they kind of like it when I say that. But it leaves that impression with the jury, right? It leaves that impression that we are, suggesting that something nefarious was happening. So you have to be very careful with calling them out on a personal level. And I wouldn't necessarily take that example and put it into your jury addresses, but it's just something that the way you do it is important. We're going to get to that in the crafting. And so generally, these are the points that I would say would attract a complaint. It would attract a complaint from the Crown Attorney, and it might attract some kind of address by the judge to the jury, and they might correct you on that. So you want to avoid that. If you want to not get any corrective instruction, these are the types of things I recommend avoid at all costs, because that would be number one. And there's one other thing we'll get into in crafting the jury instruction, but there's the way you state the law is also very critical. If you misstate the law, you're going to get a corrective instruction. And as dumb as this sounds, it happens mostly on how defense state reasonable doubt and how we present reasonable doubt. There used to be this, counsel used to do this thing where they walk across the jury box and say, if middle of the table here is 50%, reasonable doubt is way down here closer to the end here, and they'll put like a finger down and say this is basically how close they have to be to absolute certainty. And judges don't like that, because you're leaving this visual impression with the jury that you are asking them to go all the way almost to absolute certainty. So a lot of old counsel used to do that. I've seen corrective instructions on that. And so now you're getting new judges who are saying, well, that leaves a false impression. So you can't do that because it's not consistent with, Starr and Lifkis and the way the law is broken down. So you have to be a little careful with how you state the law. And when we get into the next aspect of the presentation, which is crafting the address, I'll give you some tips on how to properly address the law. So those are the do's and don'ts. Those are the don'ts. And I think that they're pretty clear, because this is what's going to happen. And the consequences could be fatal, because in a jury trial, the judge is going to do everything they can to endear themselves to the jury. And it's, so terrible. They'll be, well, members of the jury, you're going for lunch now. It's not going to be anything special. You're not going to get steak and lobster, but and the jury all laughs. Ah, it's so funny. And that goes on every day for 3 weeks. And by the end, they're like, the judge thinks and the jury thinks the judge is their best friend. So if the judge says to the jury at the end of the trial, hey, defense counsel did something wrong, the jury's going to look at it and be like, oh, well, my best friend is telling me that the defense counsel did something wrong. So I have a problem with that. Now I have a problem with defense counsel. They're not my friend. And don't forget, judges were lawyers. Judges have seen a lot of jury trials. Even the ones who weren't jury lawyers, as judges, they've seen a lot and they see what works. And they spend this entire time endearing themselves to the jury. And when they endear themselves to the jury, you feel that they're not on your side, because they have to be fair and they have to try to provide a fair representation of what's going on. But at the same time, it always feels like they're tilting the jury towards a conviction. So you don't want them to criticize you as counsel for doing something wrong. That's why it's really, really important to follow those simple rules when you're crafting an address. The way you're going to avoid that is by focusing on how you craft your address.
And Marco, before we move on to the do's, can you say a few things about when you should object to the Crown's closing?
Oh, yeah. Not rarely, you listen, if the Crown does any of the don'ts that I just pointed out, you have a little checklist here. And if that checklist, you follow it along and you listen carefully. Complaining about a jury address is hard because it's happening and you're trying to take notes and you're trying to listen, you're trying to watch the jury. So you're not really being precise in your notes or your note taking. But if something stands out, it's got to be one of those 6 don'ts. Did they criticize the defense lawyer on a personal level? Did they misstate the evidence? The misstatement of the evidence is very difficult to catch. So if they've used imprecise language and they've misstated the evidence, you might object and say, we want a correction on those points. If they've misstated the law, it's also a big deal. So follow the same checklist. And if they've offended any of those don'ts, then you can object and see what the judge says. And the judge will often ask the Crown to respond and ask them what their response is. And then based on that response, the judge will decide. I have had successful objections to Crown closings, and those objections, you never really get a super strong caution, but you get a caution, and it's bad because nobody should be offending those rules.
Okay, could we have the next slide, please? Okay, Marco, so you've avoided the judicial consequences of not crossing the line. Let's discuss how to do a good job on the right side of the line. So could you tell us first how to engage with the jury in the courtroom during your closing address?
So by the time you get to the closing, you have developed a fake relationship with the jury in your head. You think juror number 5 is your friend. You think juror number 8 hates you. All these things have happened. They're all fake, but they're happening in your head. So you're building this relationship as the trial goes on. So by the time you get to the jury address, you have to kind of focus on who am I speaking to, when am I speaking to these people? Who needs to be won over at some points in time, and who do I have in my pocket on these issues? So you look at them with this fake perception in your head of how they have responded to your questions as you've conducted the jury trial. Now, obviously, number 1 is eye contact. You want to make eye contact with various jurors throughout the course of the address. And the way you speak is important. Cadence, tone, language that you use is also very important. That's how you engage them and keep them close. What I also do is I set up the podium right in front of the jury box. I don't want the jury to look across the courtroom at me, across the Crown attorneys at me, so that when I say something, the Crown rolls their eyes, the jury sees that. I stand directly in front of the jury so that they can't see anything but me, and I don't let them. If I see somebody look away or look past me, I look at them and then they look back at you because they're literally 5 feet in front of you, not even. So that's how you engage the jury. You bring them into you and you don't give them a chance to look elsewhere because you're only going to be here for a short period of time and you want to make sure you've grasped their attention.
And how long should your closing address to the jury be?
My rule of thumb is 1 hour for every month your trial took. Okay, so I've done the longest jury address I've done was a three-hour jury address for a 3-month trial. Generally, I try to keep them an hour or less. The Crown attorney is going to bore them. The Crown attorney has to go through all this meticulous evidence that they've led and explain why they led it and explain what it means. That's not what our role is. Our role is to tell them why your client should be acquitted, not convicted. So you have to be quick, you have to be pithy, and you have to keep their attention. And doing it in an hour or less demonstrates how confident you are, in my opinion, in your case.
And how short should the address be? How low can you go?
Well, it depends on the case, but I've seen jury addresses where people have done 15 minutes and they just stand up and say, it's a one witness case. They've destroyed them in cross-examination. And they just basically said, look, here are all the problems with her evidence or his evidence. Here's all the problems that I say why you should acquit this person. And, basically, let's not waste more time. So you can keep it down, but you have to get through. I mean, mine take at least 8 minutes because my introduction's 8 minutes long. So I start at 8 minutes and then I get into it.
Can you speak about how to use evidence during your closing?
well, obviously you have to rely on evidence when you're making your submissions. Lately, I have been doing a lot to use videos. The last jury address I did was, it was a very video heavy trial. We did a great, my Nicola Perry, who was my articling student this year, assisted with developing this slideshow presentation where all the relevant videos that we want, we just looped them so that the jury, it was on the screen, and as I'm talking, the jury's watching that same 6 seconds on a loop over and over again throughout a 3-minute period. So, you're shoving it down their throat, and you can do that. It's like subliminal messaging. Crown attorneys never think of things like this. So you put it on a video, you use a video, you put it on the screen, it's a piece of evidence, and it's an exhibit. And you say, look at exhibit 6, look at this clip from exhibit 6. And we just showed it over and over again of a guy looking like he was reaching for his gun. And, we kept saying, the Crown said this person didn't have a gun, but what's he grabbing right here? What's he grabbing right here? And you just keep showing him doing that. And it kind of like leaves that impression with them. So yeah, right now, young, especially recent calls and people who are tech familiar, don't be afraid to rely on the evidence, and don't be afraid to rely on slideshows. One tip that I have is get one of your friends to help you. There's nothing wrong with showing up the day of a jury address and say, Your Honor, I have my colleague, Mr. Smith, who's here to assist me in my jury address. They're going to operate the audio visual. That helps. The judge is not going to say, no, you're not allowed to do that. And then you can just say it to the jury. Members of the jury, thank you for being here today. I brought Mr. Smith. He's just going to help me with the videos. And the jury will just ignore them and just focus on what you need to do. Bring somebody to help you and use that evidence, because that evidence it should be working to your advantage if you've let it for a particular reason.
Okay, how should you comport yourself during your closing address?
The two main important things, I think, are passion and confidence. Confidence in the outcome that you're advocating for, the obvious outcome, the common sense outcome in the case. You want this person should be acquitted. That's where your confidence should be. And you should be passionate in delivering that. I think that at the end of this, James and I have provided a couple of older articles from Art Maloney and G. Arthur Martin. Obviously, a lot of the things that they write about are not necessarily applicable today, so be careful. But the general principles are interesting. And one quote that I have from Arthur Maloney is that he said, I agree that you should not go to jail with your client, but I have some difficulty in understanding the temperament of a counsel who does not acquire some feeling for the client he represents and the cause he is advancing. To the extent that you must identify yourself with your client, in this sense, you are in truth your client's alter ego. And that's the reality. You are the voice for your client. You are the reasonable voice. You are the voice who's presenting common sense. You are the voice who's saying to the jury, forget all this bad stuff the Crown is saying about my client. Here's the law. The law asks you to apply common sense. Use your common sense and send this man home. So you have to have that confidence and you have to have that passion. And, we just hear a presentation about a wrongful conviction. And if you need passion when you're doing your closing address, just think about that in that moment, that your client is going to go to jail for a significant period of time right now, and draw that like an actor would draw those passions into your voice when you're delivering your address. So when you're crafting your address, I think we're going to get into that next. When you're crafting your address, you have to find parts where you can really find that passion.
Sounds good. Okay, so that's delivering the closing address. Let's speak a bit about preparing the closing address. When should you start preparing the address?
The moment I know my case is going to be a jury trial, I start thinking about how would I present this to the jury. You've done the forms, you're prepared, you know what the evidence is, you've done a prelim sometimes. You start thinking about it at the outline, but you should have an outline of your jury address kind of started even before the trial starts. What am I going to say? What are the important points? And what are the things that I want to convey to this jury? That's the starting point. And the other thing I recommend is you should draft a generic introduction before you even start the trial. You should just draft a generic introduction. And what I mean by a generic introduction is things that include, you thank the jury for their time and attention, referring to legal principles like reasonable doubt, presumption of innocence, rule of law, the adversarial process, all of these things that you want to put in an introduction that are going to convey upon the jury the solemnity of the process and how serious this is. You want to draft this in advance. You can make a subtle reference to rule of law, to wrongful convictions. And you also want to say to the jury that this is important for your client and that the reason why he's picked 12 people for his jury, for his trial to try him rather than a judge alone is because he has faith in the members of the community. That has nothing to do with this particular case. So you can draft a generic, when I say generic, where all these legal principles are all mapped out, you have it all the way you like it, and then you have a starting point. And the reason why you want this is because at the end of the trial, when you're spent and you're exhausted, writing a jury address is hard. So it's nice to have an introduction already done because it prevents any writer's block. It's, where do I start? Well, I have this generic introduction. So I have a generic introduction that I've been using for years. So I always feel comfortable with that. But it doesn't mean that I use that same one all the time. Sometimes I'll do, but I know it's there. So in some cases, I'll do a cold open, right? And what I mean by a cold open is I won't go to my standard generic, thank you for members of the jury, et cetera. I'll start with, Mr. G should be acquitted of these charges. The reason why he should be acquitted is because the Crown's case, and I'll just get right into it for maybe a couple minutes, and then I'll stop and I'll say, before I get into the evidence more thoroughly, and I'll go into my generic introduction, I'd like to thank you all for your careful attention in this matter. And then you talk about reasonable doubt, and you say reasonable doubt is not based on sympathy or prejudice. It's not frivolous or imaginary. Those sorts of principles that you relate, they come from the Watts manual on jury instructions. I try to use the exact language that the judge is going to use to the jury so that there's no discrepancy. I'm going to not get that complaint that I misstated the law because I'm saying exactly what the judge says. And the other thing is, to the little that I talk about the law, I want it to be exactly in the same words that the judge uses because, as I said before, the judge is going to be the jury's best friend by the end of the day. And so if you're saying exactly what the judge says, they're going to think the judge and I are best friends, even though we despise each other by that point in the trial. Okay. So draft the generic introduction. I think the generic introduction can be drafted at any point in time. It doesn't have to be drafted when you're in the trial. Take some time on a weekend, sit down. What would I say to a jury? And draft a generic introduction. Have that in your repertoire. Ask people for precedents if you want, somebody who's done one, and just kind of mold it and make it something of your own. And the second reason why that's important too is because that's something you can practice without even having to worry about the jury trial. And so because you can practice it, you get that comfort level because we're not natural orators. So when you get up in front of a jury, you want to be able to say something that you're comfortable saying easily. And it kind of gets your juices flowing because it's solemn and it's about reasonable doubt, it's about presumption of innocence. And that's what we're there for. And so you say all these principles and you know more than the jury about this stuff. And it gets you hyped up for the rest of your address.
Okay, can you say a bit more about how you use templates to prepare your address? You've mentioned specimen jury instructions, but for example, what if there's a witness or witnesses that have particularly suspect evidence that you want to do your best to attack?
Yeah, that's a good question. And I use the specimen jury instruction. I also use it for instance, the specimen jury instructions will say to a jury, when you assess a witness, you have to consider some of the following questions. Did the witness seem honest? Did the witness have a reason to tell the truth? Did the witness have an interest in the outcome? Did the witness make accurate or complete observations? The judge tells the jury these things. It's in the specimen jury instruction, right? So you go through the preliminary instructions, like how to assess evidence. This is what the judge will be telling the jury. So what I do in my jury address is I say, His Honor will guide you on how to assess the evidence. His Honor will might tell you some legal principles that apply, how to assess a witness. His Honor might say, did the witness seem honest? Did the witness have a reason to not tell the truth? And I'm basically using the exact words that the judge is going to say to the jury. And I'm going to say, when the judge says these things to you, consider witness X, knowing that these are the types of questions that you're going to be asked to consider. Mr. X was dishonest when he said this. Mr. X had an interest in the outcome of the case. These are the important things that His Honor is going to tell you to consider. And I'm going to ask you to consider them. And then I apply it to the evidence so that I'm 100% aligned with how the judge is going to ask the jury to assess the evidence. And then I'm going to take that exact assessment and apply the facts to it and say, when the judge tell you these things, use it to my client's benefit. And I do the same thing with the charge that they're facing, right? Like, it's more complicated if it's a homicide case, but in a case, for instance, where it's an uttering threats, you look at the specimen jury instruction, it says the charge asks you whether to consider the accused through word of mouth knowingly uttered something to the complainant of threat or bodily harm. So you use the exact wording from the charge, and then you apply it to the facts, right? And you say, that's what the judge is going to tell you to consider. Now let's look at the evidence. Mr. X did not utter a threat. Witness B said he didn't say anything. Witness X said he didn't say anything either. This is consistent with his own evidence that he never uttered the threat. And so here's a simple legal principle, and then here's the evidence that's important to it and what you want the jury to consider. So you just take it from what the judge is going to use, and then you just use it yourself. You steal it, and you get to go first. So it looks like you're, on line with the judge.
Okay, so if the accused testifies in the trial, how should you address the testimony of the accused? And in particular, how do you address any evidence that's particularly unhelpful to your client?
If my client testifies, the accused testimony is the most important part of my closing address because I want the jury to accept his testimony. So I do not address the second branch of WD. To me, the second branch of WD is too cute for a jury. We don't, you don't have to believe them, but if you're left in reasonable doubt, you should still quit. We don't have to say that. The judge will say that. My point is, believe my client. Here is why you should believe him. Here are the points of his evidence that are worthy of belief and why he should be acquitted. You can't shy away from the problems with his evidence or her evidence. You can't shy away from a rigorous cross-examination that, made him be unreliable on various other points. You have to address them. Why were they unreliable? What were their explanations? And sometimes it's just a matter of saying, he's a witness like anybody else, except he has a lot more to lose. So obviously, when he's testifying about something, consider the circumstances that put him in the witness box and whether or not he was reliable or unreliable on a particular point. Is that point relevant to the case? So you address, don't shy away from the frailties of his evidence. But the number one thing is to say he denied the offense. This is his explanation. You should accept his explanation. And then the next step is you attack the Crown's case and you say, look, the Crown has to prove it. The Crown said A, B, C, and D. And we say this was all untrue. And we have my client's testimony that also contradicts it. And you want to leave the jury with, do I acquit him on his evidence or do I believe the Crown's case? So when they have two options, the jury's sitting there, they're thinking, okay, well, the defense fought for his client's testimony. The Crown is saying that their police and their investigation is the way to go and we should convict. And now all of a sudden the judge comes in and says, wait a second, there's a third way that you could send this man home. Even if you didn't believe the accused, but you're left in doubt by his evidence, then the jury is saying, wait a second, we don't have to reconcile these two competing theories that were put to us by the two lawyers. We have an out. They might take that out. Anybody who's on that fence in that jury might take that out. And so it's good if the judge gives them that out and says, whatever tension you had between these two opposing theories, let's reconcile that tension by giving them that out. That's why I don't address that out, because I think that out is, you want to be confident in your theory, and your theory is not, you don't give alternative theories to a jury. That's almost a standard rule. You don't say it wasn't my guy, but if it was self-defense. You don't say that to a jury. That's crazy. You're going to get convicted for sure. Juries don't expect that. They want to know what your client's story is and what your theory is. And they're going to say, what's the Crown's theory? And then the judge will tell them all these other ways that they can acquit your client, namely the second branch of WD. And so now all of a sudden, the jury is left with an answer to that tension that a good trial has given them. It's given them two opposing sides and then a middle ground that might send this person home. That's what you want.
And if the accused does not testify, how do you deal with that in your closing?
When the accused does not testify, you're handed the advantage of closing to the jury last. So the Crown will testify first, will close first, and then you will do your closing address second. So you have the benefit of hearing what they have to say. But if the accused doesn't testify, the Crown can't comment on that. No one can comment on it. The judge will tell the jury that he doesn't have to testify. He's not expected to testify. She's not expected to testify. So when you go to your closing address to the jury, you identify all the frailties in the Crown's case, and you want to leave the impression that my client had nothing to say because he doesn't have a case to answer to here. This is how bad their case is. So if that's the ultimate goal when the accused doesn't testify, is to be able to take apart the Crown's case so much that it leaves the impression with the jury that what's left for my client to say, there's really nothing here to respond to. That's, in my opinion, the goal when the accused doesn't testify.
Okay, moving back to the delivery of the address, how do you use notes when you're closing to the jury?
So when you read or look at all of these historical texts about closing address, they'll all say, don't read to the jury. You don't want to read to the jury. I agree. I know lawyers who have been very successful in jury trials and they read to the jury because they're just not comfortable in doing it. You can get over it, I think. And I think that it comes with preparation. I craft a jury address in a speech in my own voice. I craft it throughout the course of the trial. I start working on it as the trial's going. At the beginning of the trial, I have my generic introduction. I have my outline as to what I want to say. And then as the evidence comes out, every night, I take a piece of evidence and I kind of summarize it into my address. And I work on it throughout the course of the trial. It's much longer than it needs to be before I get to the end, but I work on it all the way through. And then what I do is I record it. I read it and I record myself on my phone. I just record the jury address and then I listen to it back, and I follow along, and that's where I start noticing things that I want to close or sharpen, or things that might call into question some of the evidence, because the things that I've written them on day 4 of a 30-day trial. You might not reflect. So let me go back and check that. All of this has to be done in advance of the night before. You have to get all that done. And then once you get to the end and how you want your address to go, you start honing it down by listening to it, by scratching things out, by making sure that it's compelling. So that's how I prepare it. In my draft closing, I make notes. So I'm writing a speech. I'm not writing a legal submission or a fact. I'm writing a speech. So I'll make a note. Look at juror number 6 on this point. I'll make a note. Long pause here. I'll make another note. Look at juror number 3 for this point. Because as I said, you've created this fictional relationship in your mind that these people are following along in a way that you think that they are. So you focus certain portions of your closing address on certain people in your jury. You take pauses, you take breaths, you remind yourself, this is an important point, repeat it. So I'll repeat it. So some counsel will say, when they stand up there, just have talking points and deliver your address in a very casual way. I don't feel comfortable doing that. And I think that a lot of people, when you watch a lawyer do it in that way, you'll notice they tend to be somewhat repetitive. And when you start to repeat yourself, you start to lose the jury a little bit. So I'm very deliberate in my closing. If I'm repeating something, I'm repeating it because it's written in my speech to repeat it. By the time I deliver the speech, I've heard it so many times that I have it in front of me and I'm comfortable with it. I make the font big so that it looks really thick, but it's, you know, and I put spaces and I put pauses, I bold and I italicize certain things. By the time I deliver that speech, I feel like I know it off by heart, even though I don't. And I have portions of it in my mind that I want to change as I go along. Or sometimes I just have something where I'll say, if the moment calls for it, just say it. Just say what you have to say right at this time. And I've done that, because you should never feel compelled that my speech is done and I'm never going to tinker with it. You're tinkering with it literally right before you stand up to deliver it. You're adding something. You might add a little, oh, let me change this. Let me add this. Or you might hear something that the Crown says that you didn't think of. You want to add to it. So I write it on the back side of the previous page with an arrow and a note. Sometimes use sticky notes or whatever, but you have to be willing to change it on the fly. And when you listen to it back, when you're recording yourself and you're listening to it back, you're listening, the intonation is good. It's not good. And if there's something that you're stuck on, and I was stuck on my last one that I did, I didn't like how I ended it. Like, there was a part of the ending I didn't like. It was so easy for me to just send it an audio to my friend and say, listen to just these 2 minutes. You don't have to listen to the whole hour. Listen to the 2 minutes and let me know if there's something in there that I can change. And they'll listen to it. And then they'll say, you know what, I think you should say it this way, and give you some ideas. So recording it is like such a useful tool. And listening to it back is important. So, and you're reciting it to yourself by doing that.
Okay, how should you use rhetorical devices in your address to the jury?
So obviously you don't want to come across as though you're rigid. You want to be conversational to a certain extent, even though no one's responding with these jurors. So you want to use some rhetorical devices. You just got to be careful. And this is why, listening to it back, I noticed sometimes I overuse rhetorical questions. Sometimes I overuse things like puns. Like, I try to avoid using puns or hyperbole, but like figures of speech, you might overuse them because you're not writing it all in one sitting. You're doing it over a course of time, and your mind tends to be like, well, how can I address this point? I'll use this rhetorical question, or I'll use this figure of speech. And then you do it over and over again. And then when you listen to it back, you're like, how many times am I going to say this line? How many times am I going to use a rhetorical question? And the concern is, by using these devices, do I sound sarcastic? Do I sound flippant? So you want to avoid, like, you want to use them sparingly and to make important points. One thing I did in a recent closing address is that I came up with a rhetorical question because I was criticizing the police, and it was, why must my client suffer for the failures of the police? And I put it on the screen and I left it, and then it would come down, and then every time I'd say it, it'd come back on the screen. And it was like a recurring theme every time I criticized the police. You can use things like that. You're allowed to do that. No one's going to stop you from doing that, because none of that stuff goes in the jury room with them. It's just part of your presentation. But I would avoid hyperbole. Like, you don't want to say the witness lied 1,000,000 times, because the witness didn't lie 1,000,000 times. You have the evidence. We got to be precise with the evidence. You don't want to say things like, well, the witness was in so much denial, you would think he was a river in Egypt. Like, you don't want to say things like that. These jokes, like, yes, you want to be, but it comes across sarcastic. You want to say the witness became a wee bit upset at that point. That's not, we're not trying to be sarcastic. We're not trying to embellish or understatements. So those are not helpful. And again, pauses and tones really do a number, because when you pause, you make a big point, and you pause and you stare at somebody, they're looking at you going, why the hell is this guy staring at me? This must be important. And then you look at the next person, and it works. It does work. The other thing I just want to say is, you want to leave it all there. I imagine myself, like, in the course of a trial, our robes, we're a body in these robes. We all dressed alike for a reason, so that the jury can focus on the evidence, so that the jury can focus on the accused. When we finish that jury address, it has to end with you feeling that there's nothing left that you could have done for this person, and that you have to feel that way. And your number one fan after that jury address has to be your client. When your client says to you, thank you, no one's ever spoken up for me like that. That's in your mind, even if he gets convicted, you know that this person sat there and listened to somebody actually defend them. Because the clients, they don't really understand a nuanced cross-examination. They don't really understand, they think that they're against the system, but they don't really understand as much as they do when you stand up and say that this person should be sent home because our society shouldn't convict them on this evidence. And when they say thank you to you for that, they feel it. They feel that somebody is there for me. And that's the important thing. So that's the last point I want to leave you on, because you come to these conferences to be inspired. The state of the law right now, as far as I'm concerned, is not very defense friendly. Judges, legal rulings, evidence kind of all goes against us right now. So sometimes taking a view towards putting cases in front of juries should be more common. And I want to encourage a lot of you to start thinking about that. Don't get bullied out of it, because judges, and nobody wants you to go in front of juries because they want to have that control over the process. Don't be afraid to put your case in front of a jury. Oftentimes, the worst cases are the ones that juries should hear, because the jury will look at it from 12 different perspectives, as opposed to a judge who's just sitting there saying, oh, I've seen this a million times. This guy's so obviously guilty. So put things in front of juries. Don't be bullied out of it. And when you do it, you're going to feel that when you close to a jury and you ask them to send your client home, and your client thanks you for all the work that you've done in front of a jury, it's the best feeling, because the only better feeling is to hear the not guilty. That's the only thing that's better. So I encourage everybody to really start taking a view towards putting cases in front of juries as much as you can, when you can, because our system is not really helping us from any other legal perspective to get acquittals for our clients. I'm available for Q&As.
Thanks, Marco. Tanya, do we have a couple of minutes for questions?
Maybe just like 1 minute, literally.
Okay.
I forgot I had to.
Does anyone have a short question?
Yes, go ahead. I'll speak loudly. When, if ever, do you stand up while the Crown is addressing a jury and object to something they said?
I've never, I should have said that at the outset. Never do that. Let them finish what they have to say. Closing address to the jury, they can close. When the jury will be excused, you can make your objections at that point. I never interrupted, and I've never been interrupted. I've said things that possibly I shouldn't have said. I've been criticized, I've been in trouble, been objected to, but I would be shocked if anybody objected in front of the jury, because if the objection is unwarranted, then there's no turning back from that. So that's a 100% never do that. But that's a good question that I should have addressed. And guys, I know it's been a long day, so I thanks for your attention at the end of the day on this topic.
And thank you. Sorry, I let you guys. I started you guys late, but I also let you go late. So I apologize. I just didn't want to cut off Ms. Shepherd from giving that important keynote. So thank you so much for
Thanks, guys.
assisting today.